Hello, everybody. As Lois said, my name is Alison Ward, and I'm a lawyer at CLAS, and I run the advocate support line. For those of you that I've met in person before, it's really lovely to see you again. It feels weird, but also wonderful to be back in person. And for those that I haven't met yet in person, looking forward to meeting you. My job here today is just to give a brief update about changes in welfare law over the last year, since we were all staring into Zoom screens last October when I last gave a welfare update at the beginning of the conference. Some years it's a lot of changes and can be like a lot of detail and quite overwhelming. Happily or unhappily, this year there have not been that many changes. There's just a total of 5 changes in regulation and policy this year that I'm going to run through quickly. I do have a slide deck, and hopefully I can figure out how to run it. So the first change that I want to talk about is probably the least exciting of the changes. But as you know, over the last 2 years, there were a lot of changes to keep up with welfare law, as various pandemic benefits were introduced and then exempted, mostly for people who were on income assistance prior to the pandemic. So I just want to address what's happened with that there. So as most of you know, there was a group of people on income assistance or disability assistance prior to the pandemic, or who had the PWD designation prior to the pandemic. So for that group of folks who on April 2nd, 2020 had the PWD designation or were on benefits, special rules applied to them. So that pandemic benefits, including CRB, Canada Recovery Benefit, kind of CERB paid through EI at the start of the pandemic, and then later the Canada Worker Lockdown Benefit were exempted as income and assets for that discrete group of folks. That is now fairly moot. 2 things happened this year. One is, always in the welfare legislation, there was a date when those exemptions were going to expire. The section said, oh, it's going to be, those exemptions will end in September 2020. Then it got extended to like February 2021 and on and on. One thing that happened this year is the expiry date was eliminated. So those sections are just written into the welfare legislation now, but they are fairly moot because none of those benefits remain in pay. The only reason it's important to remember that those still exist is because you may have people that have disputes regarding benefit eligibility. Maybe after an appeal, they'll become entitled to something retroactively. Maybe there's an EI eligibility appeal and they become entitled to some EI that was payable prior to November 21st, 2021. If that's the case, the exemption still stands for them. But for most other folks, it's fairly moot at this point, and so there's not too much to remember about those for most advocates in the room. Another change that happened this year happened as a result of a lot of work that I know some advocates in this room did. There was a very unfortunate pandemic-related effect that happened for many low-income seniors. So seniors who were receiving guaranteed income supplement, which is a supplement to the old age security pension, folks on GIS have an earnings exemption currently of $5,000 a year with no reduction in GIS benefits. And if you earn a little bit more than that, you have an incremental deduction in your GIS benefits. So a lot of those folks were working prior to the pandemic on a part-time basis and utilizing their earnings exemption. Then when the pandemic hit, they could no longer work and they were qualified for CERB or the recovery benefit based on the income they'd had. And they applied for and they received it. And I don't think anybody expected what happened next, which was that when you calculate eligibility for GIS benefits, the year of GIS benefits runs from July of one year till June of the next. And because it's income tested, the income that it's tested against is the income you had in the prior calendar year. So folks on GIS who had CERB or recovery benefit income in 2020, when July of 2021 hit, what happened was that income was not considered exempt for GIS purposes, and thousands of seniors across the country lost their GIS benefits or had them significantly reduced. I think many of you saw clients in that situation. They may have come to you for income security issues, or they may have come to you with an eviction notice because they couldn't pay their rent because they'd lost their GIS. So it caused a lot of pain and hardship. And it has now been rectified, but it took quite a long time. And two things happened. At the federal level, in March of 2022, the Old Age Security Act was amended so that that problem going forward will be eliminated. We won't see seniors losing their GIS because of pandemic benefits again. And at the level of income assistance and disability assistance, in May of 2022, we see an exemption for compensation that the federal government paid to folks that had lost their GIS benefits for this reason. So compensation was paid by the federal government automatically. So your client shouldn't have to apply for it. It should come automatically. And the amount of the payment should be equal to whatever amount of GIS benefits they lost out on because of pandemic income. And it's the benefits that they lost out on from July 2021 onward until the payments were made in April of this year. So it's an important change. From an advocacy perspective, there's not too much that you need to do. It's important to know what happened, but the federal payments should be automatic, and the exemption at the ministry level should be applied automatically as well. However, if you have a client that you know lost out on the GIS benefits who comes back to see you, you may just want to make sure that, oh, did you receive your compensation payment as you were supposed to? Because of course, glitches always happen. All right. So the next topic I want to talk about is the new minimum shelter allowance, which was introduced by the ministry this year. There's a regulatory change and a broadening of policy about shelter allowance. And shout out to some people in this room as well here who I know have over years of advocating for the ministry to apply their actual shelter cost policy more broadly, and by sharing stories of clients who are living in non-traditional housing situations and do have expenses associated with them, have finally resulted in some incremental change so that folks who are living in non-traditional situations can finally access some shelter benefits each month. So this change took effect on May of this year and is applicable to all forms of welfare benefits. So whether people receive income assistance, PPMB, hardship or disability assistance, everybody on benefits other than people in special care facilities who have their housing covered, is entitled now to a minimum shelter benefit, even if they don't have what the ministry calls actual shelter costs. So in the welfare legislation, there's a very specific definition of what constitutes an actual shelter cost. And I've got a summary of it on the slide there. So that can include rent or mortgage payments on a place of residence, utility costs, and other expenses if the residence is owned by someone in the family unit. What's happened really is that the ministry has started to take a more broad view of what constitutes a place of residence in their policy. And with the regulatory amendment, even if somebody has no proof of actual shelter costs, they will still be entitled to the new minimum shelter allowance. I've got a couple more slides on this topic. We'll run through them. I think I got ahead of myself and I've already talked about the two major impacts of the change. So again, if somebody can show that they live in a non-traditional setting, so they live perhaps in a tent, in a car, on a boat. There's no end of situations that could be covered here. The ministry policy now formally recognizes that that can be the person's place of residence. And so the ministry can consider rent or rent-like charges associated with that place of residence. So I've included an extract of the ministry policy on shelter costs in SCED. You'll see there's an upload there that you can look at, and I've got the policy hyperlinked on that page because there's a lot of detail in the policy that I think will be quite helpful for some of your clients. And some of the helpful part of the policy is actually lost somewhat in the procedures section. So you'll see the PDF that I've uploaded to SCED includes both the policy and procedures section. So in there, there are examples given of actual shelter costs that the ministry can now consider under this policy. So it includes things like campsite fees, for example, dock fees, hookup fees for water or septic, and wood and or fuel of any sort for cooking and heating. So for those clients that can show, regardless of where they're living, that they have actual shelter costs of, say, $100 or $150 a month, they should be able to access that much of their shelter portion. And then for clients who cannot show that they have actual shelter expenses above the minimum amount, the minimum amount for a single person is $75. So if they can't show that they have actual shelter costs above $75, they'll still get the minimum $75 a month on a monthly basis. Got one final slide, which just runs through the amounts. Now in the regulations, we have a minimum shelter amount, and the old shelter maximum is still there as another column in the table for maximum shelter allowance. I just extracted up to family units of 5. You'll see that as family unit grows, the minimum will increase by $25 per person per month, and the maximum will increase by $50 per person per month. The minimum shelter allowance for people who haven't prior to this change been receiving any shelter allowance should be applied pretty much automatically. So we know, for example, that for a single person on income assistance, the support rate is $560 a month. You really shouldn't be seeing anybody with a welfare check for $560 a month. I know many of us have these numbers memorized. You should be, the magic number you want to look for is 560 plus. They should also be receiving at least 75 for their shelter expenses. So that becomes $635 a month should be the lowest check amount you should be looking for. And any client that you see who's only receiving $75 in minimum shelter allowance, you should be running through with them. Oh, what are your actual shelter expenses? Under this policy now, there are other expenses that you might be able to have covered. Maybe if we can show that your actual shelter expenses are more than $75 a month, we can get you access to a higher shelter benefit level. So keep your eyes out for that. Another change that happened this year has to do with the armed conflict in Ukraine. There is a new category of hardship assistance that was created. It's not created specifically for people fleeing Ukraine, but at the moment, that's the only group of people that can access this type of benefit. So it's a new category of hardship assistance created on July 1st, 2022. And in order to qualify for hardship assistance, of course, the person has to be ineligible for income assistance for other reasons. So people that are fleeing Ukraine come to Canada on under a special immigration program. They're not refugee claimants. So without this change, they would not have the immigration status they need to qualify for income assistance or disability assistance. So this change recognizes the immigration status that they do have. People fleeing armed conflict in Ukraine are coming to Canada under a temporary resident permit for a 3-year period that's issued under an emergency authorization by Immigration Canada for humanitarian reasons related to armed conflict. So they are not refugee claimants. They're here on this visa, temporary resident permit for 3 years. And under this new category of hardship assistance, they are able to access a total of 6 months of hardship assistance, not 6 months per year, 6 months total. It can be consecutive or it can be intermittent as they have need. This type of hardship assistance is not repayable, and it includes access to an earnings exemption after the family unit has received hardship for 1 month. So the earnings exemption that they would be eligible for will match the earnings exemption for the type of family unit they're in. So for a single person on income assistance, $500 a month, a family unit with a child, parent and child, or 2 parents and a child, $750 a month, and so on. Another interesting thing about this category of hardship is that there is kind of a unique exemption for income and assets. So it recognizes that people in this category may have theoretical income or assets, such as property overseas. And it recognizes that if those things are not immediately available to the family to satisfy their basic needs, that they will be exempted for the purposes of welfare, and they can access hardship assistance regardless. That covers that slide off, and I believe I'm moving on to my last 5th change of the year. And that is with regard to exemptions, new exemptions for money that are paid under 4 settlement agreements involving various treaty and land claim issues. So there are already numerous settlement agreements that are specifically exempted in the welfare legislation. These are 4 additions that happened in the last year. So there is money paid under the Williams Treaty Settlement Agreement, which is a treaty involving 7 First Nations, primarily in Ontario. The Missinabie Cree First Nation Treaty, the Pepecasis Cree Nation File Hills Colony Specific Claim Settlement Agreement, which involves a treaty settlement in what is known as Saskatchewan, I believe, and maybe part of Manitoba. And finally, claims relating to the transfer of the Seabird Island Indian Reserve in 1959. Seabird Island is near the agreement. You may see more clients with that Seabird Island issue, but of course, people move around the country all the time. So it's important to keep up on what settlement agreements are exempt. And of course, if you look at the welfare legislation, you'll see, I don't actually know the number off the top of my head, but there are numerous other settlement agreements that are specifically exempted. So whenever you're seeing a client who is receiving money from an Indigenous settlement agreement, it's really important to find out specifically the name of the agreement that they're receiving money under, and then you search the welfare legislation and see whether or not it has been exempted already. Those exemptions took effect last November, and there have not been any changes in October. So I have covered all of the changes that I want to cover so far, and we are a little bit on the clock. So I think what I'll do is pass the microphone over to Zuzana. I think our plan generally is to keep questions for the end to make sure we can get through all of the speakers. So if you have questions about my presentation, just make a note and ask me after, or if we run out of time at this session, find me out in a break room or in another workshop in the conference. Thank you.
Hello. So like Lois said, this is basically a teaser for a longer session that's going to happen tomorrow morning at 9 a.m., which will be the housing law update. But for now, I'm going to run through the changes to residential tenancy law that have occurred in the last year, essentially, real quick. There haven't been a lot of legislative changes. In fact, really only one substantive legal change in the Residential Tenancy Act itself, and that is the addition of Section 51.1, which is the section on tenants' compensation where the tenant had a vacate clause in their tenancy agreement, and then the landlord failed to follow through with the stated purpose of the vacate clause. So for those of you who aren't familiar with this concept, a vacate clause is a term in a tenancy agreement that requires the tenant to move out at the end of the fixed term, and landlords are only allowed to do that for specific reasons that are provided for in the residential tenancy regulation. So right now, that is only if the landlord or close family member of the landlord intends in good faith to occupy the unit at the end of the fixed term. So in cases where that doesn't happen, a tenant can now apply for compensation under Section 51.1. So essentially, this is a analogous section to Section 51, subsection 2, which gave tenants the right to apply for 12-month rent compensation, where they were evicted with a 2-month notice for landlord use of property, and then the landlord failed to follow through with what was stated on the notice. So this is meant to be sort of the analogous section to that. It has taken the RTB or the legislature quite a long time to put this in play. As many of you may know, vacate clauses were restricted a number of years ago, but there was no section in the act until this July that said what happened if a landlord included a vacate clause and said it was for the one reason they were allowed to do it, but then failed to follow through. There was essentially no consequences until this July. So that's good. I would note, though, that while it is an analogous section to Section 51.2, there are some differences in how it operates. And for that, I would encourage you to read the section itself if you're not coming to our session tomorrow, and also take a look at the policy guidelines that deal with tenants' compensation for end of tenancy. One of the interesting differences is that in this section, they don't specifically say how long a landlord has to use the property for the stated purpose in the vacate clause. They actually refer to regulation, essentially leaving the door open for them to change the length of time that a landlord must occupy for more easily. It doesn't have to go through the legislature. They can just do it by order in council to alter the regulation. Another difference is that the onus to prove that the landlord hasn't used it for the stated purpose in Section 51 sub 2 is explicitly on the landlord. In Section 51.1, the new section, that is not the case. It's not set out in the section that it's explicitly on the landlord. And in fact, in policy, the RTB has said that it is on the tenant. Okay, so that's essentially it for legislative changes. The regulatory changes, the first kind of relates to Section 51.1. It says the length of time right now that a landlord has to use the property for the stated purpose is 6 months. And that's it. That's how they've done it. But that, again, can change just by order in council. The next regulatory change would be the rent increase amount for 2023. And this is a change both in the residential tenancy regulation and the manufactured home park regulation. And the reason that they've included a new section, and that section is 22.1, is that this year for 2023, they've decided to deviate from the normal formula that's set out in the regulation, which is inflation for the RTA tenancies. And so this year for RTA tenancies, the new section is 22.1 in the RTA, and it sets the maximum rent increase at 2%. And the analogous change was made in the MHPTA regulation at section 32.1. I should add that there is a short summary of these changes that I've uploaded to SCED for this section. So it's just like a one-page summary if you want something to refer to. Now, next up, the RTB has amended a number of policy guidelines, as they do most years. Anytime, I would add, that an advocate, any of you want to use a policy guideline and rely on it in a hearing, always go to the policy guideline on the website to make sure that you're using the latest version, because they update these throughout the year and there's no announcement to anybody that they've done it. They just do it. So that said, first, I'm just going to run through these fast. Most of them are not super substantive, but again, if you want to rely on any policy guidelines, make sure you're looking to the most recent one. Policy guideline 23, which is a policy guideline about amending applications. The addition there is just that the procedure for amending applications for dispute resolution online through the dispute portal. Policy guideline 23 and 24, which are the policy guidelines on review, consideration, or application for correction. Essentially have been updated to say that parties cannot submit recordings with their application for review, consideration, or clarification correction. And arbitrators won't listen to any recordings that are submitted except when it would be a breach of procedural fairness, which of course begs the question how they're going to know it would be a breach of procedural fairness if they don't listen to them. Next policy guideline 30, which is the policy guideline about fixed term tenancies, and that was amended to add the content for the 12-month rent compensation under the new section 51.1. Policy guideline 37 amended to reflect max rent increases for 2022. That is the guideline on rent increases in general. Policy guideline 41 is about administrative penalties. It probably will not be relevant to many advocates, but it is interesting. So if you do want to look at the policy guideline on admin penalties, it has been revamped. Policy guideline 43 is an updated policy guideline on naming parties. This is an important policy guideline, and we will go through it in detail in our session tomorrow morning. But if you're not coming to that session, I would strongly encourage you all to read it. It is very important to make sure the proper party is named when you're making an application for dispute resolution on behalf of a client or on behalf of yourself, I suppose. This policy guideline sets out information about that, as well as what you can and maybe can't do if you have named the wrong party or made a spelling error or something of that sort. Policy guideline 44 was updated to include a section on requesting alternate hearing formats. Policy guideline 47, which is the policy guideline about access to information and records, was updated to include information about obtaining recordings of hearings, because as many of you who do these hearings know, they have started recording them this year, which is a long and hard-fought battle which a lot of advocacy agencies have been trying to get them to do for a very long time. Okay, so policy guideline 49, which is the policy guideline about tenant direct requests, was entirely revamped for clarity. Policy guideline 50, which is the policy guideline about tenant compensation for end of tenancy, that was amended to include things about the new 51.1 section. And then policy guideline 44, which is the policy guideline about orders of possession, now includes a new section that talks about how arbitrators are to determine the effective date of an order of possession. And this is an answer, I think, to a lot of advocates telling the RTB that all arbitrators are defaulting to 2-day orders of possession, and that's just unfair in a lot of circumstances. So they've created a policy that I think tries to clarify that arbitrators should be exercising their discretion. I'm not sure how well the policy guideline does it, but we will see what happens in practice. That's it for the policy guidelines. There have been a number of interesting cases. How much time do I have? Oh, I'm okay. There have been a number of interesting cases this year at the BC Supreme Court and the BC Court of Appeal that have come out. And my one-page summary has a list of cases that we thought were most interesting, as well as the neutral citation that you can use to find those cases on Canly, if you want, which is the free resource to find case law in BC or in Canada. Okay, so the first case is called McClintock and British Columbia. And just real quick, what's interesting and important about this case is that the tenant here got a 1-month eviction notice for breach of a material term. The landlord did the steps they were supposed to do. They gave the tenant a warning letter saying, hey, you got a couple days to fix this. The tenant didn't fix it. The arbitrator upheld the eviction notice. Tenant goes to Supreme Court, and on judicial review, the judge says, hey, actually, when you're determining what a reasonable period of time to remedy a breach is, you have to actually take into account the tenant's circumstances. In this case, he was quite elderly, and there were some other circumstances that made it difficult for him to actually remedy the breach within the couple days the landlord had given him. And they overturned the RTB decision sort of on that basis. The other, maybe two that I want to talk about, the first is SENF and the Society for Christian Care of the Elderly, which was another eviction matter. So hold on, let me just make sure I'm saying things right. Yes, okay. So it was another eviction for cause. Essentially, the tenant was a tenant with a disability. He had some health issues. He had a cleaning service and friends helping him clean his unit before COVID hit, but once COVID hit, that all stopped. And his unit kind of became very messy. There was a lot of refuse. Landlord said there was like, biohazard materials, essentially. Whether or not that part was true, I don't know. Tenant gets an eviction notice. So before the tenant got an eviction notice, he contacted a cleaning service, got on their list, but they had a long wait list. Tenant gets the eviction notice saying you have to be out because of this. Tenant disputes. In between the time the tenant disputed the notice and the hearing, the cleaning service came and cleaned everything up. The arbitrator said, this is not what matters. What's before me is whether the landlord had cause at the time that the eviction notice was issued. So I'm upholding it because at the time it was issued, the place was a disaster, essentially. Goes to judicial review, I think for good reason. And a judge says, no. I mean, you have to, keeping in mind the sort of purpose of the RTA, which is to confer protection to tenants, essentially, you have to consider conduct of the tenant post-notice when it's this relevant to the issue of the reason for eviction. So overturned the arbitrator's ruling to uphold the eviction on that ground. So that's a very important case. You should all remember anytime that tenant gets an eviction for cause, but they've taken steps to remediate the problem, this case will be relevant. The first name? Oh, it's so the question was, what is the name of the case or the applicant? So it's SENFT. It's spelled SENFT, and it's versus the Society for Christian Care of the Elderly. And finally, the last case that I'll talk about is one called Siren and YWCA Metro Vancouver. Siren is spelled CYRENNE. And once again, these citations are all on the one-page document that I've uploaded to SCED. So this case was also an eviction for cause. The tenant was a single mom with an autistic child. The landlord essentially saying the child is making all kinds of noise. It's a 13-year-old autistic boy, making a lot of noise. A lot of other neighbors are complaining, and there were many complaints in evidence. Goes to hearing. Landlord gets to present their evidence in some detail. Tenant tries to present or counter what the landlord has said and present her own evidence, but arbitrator says, hey, we're out of time. Tenant also asked to cross-examine the landlord's witness and was denied that also because the hearing had run out of time. It went to the 90 minutes, so they extended it to 90, but the arbitrator did not want to adjourn to go further. And essentially, tenant took this to judicial review and won on a breach of procedural fairness. And some of the interesting things that came out of that case was that the judge says, hey, when the stakes are higher, the bar for procedural fairness is also higher. And in this case, you have a single mom who's on low income with an autistic son in low income housing, and she stands to lose that housing. The stakes are high, so the bar for procedural fairness should be higher. And that's it. That's all I have.
Hi, everyone. My name is Vernon Black. I am Chippewa Dene from the Prairie First Nation, Treaty 8 territory. I'm a fairly new legal advocate at the Indigenous Community Legal Clinic for UBC Allard's School of Law. And today I will provide a very brief overview of the current and upcoming Indigenous class action lawsuits, including the Federal Indian Day School settlement, the First Nations Drinking Water settlement, and the Millennium Scoop class action. So first, the Federal Indian Day School settlement, something that we've worked at a lot at the Indigenous Community Legal Clinic. And so this settlement was announced in March 2019 and is a nationwide class action lawsuit against Canada for the harm suffered at the hands of federally operated Indian day schools. As many of you know, the Federal Indian Day School system attempted to assimilate Indigenous children by removing them from their languages and their culture. Religious institutions, often ran institutions. Many of the students faced physical, emotional, and sexual abuse. There were nearly 700 Indian day schools operated across Canada between 1863 and the year 2000. On August 2019, the federal court approved the settlement, allowing survivor class members to submit claims over 2.5 years from January 13th, 2020 to July 13th, which just passed, 2022. Under this class action settlement, survivors could file claims for compensation on a tiered system of harm suffered, from level 1 to level 5, ranging from $10,000 to $200,000. Survivors making claims for levels 2 or 5 needed statements or narratives disclosing details of the abuse they suffered. The Indigenous Community Legal Clinic helped facilitate over 170 Indian day school applications, many of which happened right before the deadline. The narratives that were required to, my apologies. The narratives that we had to work with claimed to be, they were very emotionally challenging, not just to the clients, but to the students and the advocates as well, who worked painstakingly to capture the survivors' stories. I believe there's going to be a fair amount of work that's going to need for aftercare for not just the clients, but for many of the advocates who had to listen to these survivors' stories. An additional 6-month extension has been granted for the Indian Day School. From July 13th deadline is now the January 13th, 2023. So we have a little bit more time to get in some more Indian Day School applications. And next, I'll be talking about the First Nations drinking water settlements. The Indigenous Community Legal Clinic, we've only dealt with maybe a few of these settlements. Not too much experience with this, but so the courts have approved a settlement between Canada and certain First Nations and their members subject to drinking water advisory that lasted 1 year between November 20th, 1995 and June 20th of 2021. The key allegation was that Canada had breached its obligations to First Nations communities and its members by failing to ensure that reserves have clean water. It was further alleged that the Canadian government breached its fiduciary duties and various rights under the Canadian Charter of Rights and Freedoms. On October 8th, 2019, the courts granted this class action certification. The settlement includes commitments to fund infrastructure, construction, operation, and maintenance to help First Nations, class members enjoy regular access to safe drinking water in their homes. Additionally, First Nations bands may opt out of the class action, providing the bands with an opportunity to have their stories heard in hopes of advancing their rights of their communities. Individuals who participate in this class action are giving up their rights to sue the Canadian government for the claims resolved by the First Nations class action settlement. This settlement will not bind First Nations who choose not to participate. The Indigenous Community Legal Clinic has, like I said, only dealt with a couple of these cases, and the deadline to submit is March 7, 2023. My apologies. And lastly is the Millennium Scoop class action. So the Millennium Scoop class action is a lawsuit against the Canadian government on behalf of off-reserve Indigenous children and families who say the government discriminated against and harmed them amid the Millennium Scoop. So the discrimination that was outlined within has taken two forms. First, the Canadian government has denied proper funding to child welfare agencies responsible for the protection and the well-being of First Nations children. This denial of adequate funding has directly contributed to the epidemic numbers of First Nations children on reserves being removed from their homes and communities and placed into state care. Secondly, the federal government has failed to honor Jordan's Principle. Jordan's Principle is a legal requirement for the federal government to provide First Nations children with necessary services and products, regardless of which level of government must eventually pay for these products or services. In breach of Jordan's Principle and constitutional equality rights, the government has delayed or denied essential services and products of tens of thousands of First Nations children, both living on and off reserves. Last year, Canada had agreed to negotiate an agreement to end the discrimination against children living on a reserve. Those negotiations resulted in a $40 billion agreement in principle finalized December 31st, 2021. The final sale agreement determines the compensation amount, which is subject to approval by the Canadian Human Rights Tribunal and the Federal Court of Canada. Details on the compensation eligibility and application process is yet to be made available at a later date. And like I said, that was a very brief overview of Indigenous lawsuits in Canada. And thank you for your time, everyone.
Thanks, Vernon. So now we're going to have Ashley Silcock do a brief update on Canada Pension Plan issues. And Ashley is joining us remotely. So I'm just going to wait for her to appear on the screen.
Am I there on the screen yet? Oh, I think the video might have come on. Yep, they got it on. So with CPPD, there hasn't been too many major updates. The pandemic certainly slowed down some of the things that were going on there. So since we met last, they introduced a member sort of conduct complaints process. So a formalized complaint process that appellants can go through if they have an issue with a Social Security Tribunal member. And that came in actually just shortly after our last meeting last year. Other things that have come out is the Social Security Tribunal are now pushing or have expanded how you can search the decisions on their website. So they are giving sort of search options to make their website easier. However, I just end up going to Canley because that's the one I'm familiar with. And I'm guessing a lot of you guys are in sort of a similar place where you're more familiar with Canley. They have been working on sort of setting up rules for processes. Those haven't come into place, and that's a big thing that the pandemic had unfortunately really slowed down for people. They did have the proposed rules out back. And from what I've seen in the proposed rules, those look relatively good. They look like it would be a very positive change. They're written in a way that unrepresented clients or unrepresented appellants might actually be able to go to the rules of procedure, read and follow what has been put down. And if they can retain that, I think that's going to be really crucial, not just for new advocates who might be learning the system, sort of decreasing the barrier there, but also for the people who may be in situations where they can't connect with an advocate, or they may be in a province where, or an area of the province where advocacy services just aren't available. For those clients, one of the good things is that they are continuing is during COVID, the Social Security Tribunal had expanded to allow hearings to happen over video conference. Historically, what would happen is people would have, if they were going to have a video conferencing hearing, the client or the person who was the appellant would have to actually go physically to a Service Canada office and then sit in the media room there and do their hearing over that infrastructure. Whereas now they're able to do the hearings over Zoom. People, if they have access to reliable internet, are able to do their hearings from their home. Sometimes they'll come in and they can do hearings at, an advocate's office if they don't have access to that. One of the cool things that are coming out of that, plus also our organization sort of having to change our process to adapt to the COVID world, means you're hearing from somebody who falls sort of in an area where there is a gap in service, where they may not necessarily be able to get in to see an advocate, or they don't, it's an area where there just aren't advocacy services available. We may be able to assist those people through the appeals process, and potentially, if their case has merit, right through to the tribunal, where we can give them more direct assistance. The other fun thing coming out of that would also be for people who may not be as familiar with CPP, but who want to learn more about it. One of the things we can do now is sort of, if there is a client in your area that needs assistance with something around CPP, it's a little bit out of your sort of wheelhouse, but you want to learn more. As long as the client's okay with it, I'm more than willing to give feedback and to help work collaboratively on sort of files that you're trying to manage. Let's see. They have released, the Social Security Tribunal again, have released some information about their navigator service. That seems to be really popular. A lot of you guys may not be familiar with it. If somebody is trying to navigate the Social Security Tribunal process on their own, they are assigned a navigator who will actually explain the system to them. It is somebody who works for the Social Security Tribunal. So it's not quite to the level of having an advocate, but it is someone who's there to give help and guidance. Let's see, and then we have and yeah, that's the big ones for the Social Security Tribunal side of Canada Pension Plan. In terms of the benefits itself, there haven't been any major changes to the program as a whole. Just the little increases to keep up with inflation and the annual amounts that go up a little bit for everybody who's collecting the benefit. Though those systems are a little slower to change. I know right now they recently did a review of the reconsideration process at the policy level with Service Canada. And that's sort of in the works, but there haven't been any outcomes that have come from that yet. The other thing would be, I have noticed a huge increase in the number of overpayments that I'm seeing. And I've noticed a huge increase in a specific population, which would be the people who have been on the PWD benefits long-term, often who got onto the PWD benefits when the earnings exemption was, say, set at $500 a month, which is very close to what people were allowed to earn without having to risk it affecting their CPP benefits. And as the ministry's earning exemptions have gone up, some of these recipients have increased their work hours, but not necessarily met their reporting obligations to Service Canada. And I'm seeing people with quite large overpayments. It's very, very frustrating for these people. This is money that the Ministry of Social Development did deduct, in most cases, dollar for dollar. And then they end up in a position where they're having to try to repay that amount back to the federal government, even though it was an amount that got deducted by the provincial government. So I'm definitely seeing more cases like those. If you are having people in your communities talking about having issues around that, definitely reach out to us. If it's not an area that you're familiar with, it does get tricky. There are some cases that can be made in those situations, depending on the file contents. And I think that is it for now. I will say, if and when the I will update PovNet, and I'm just remembering one other thing that I wanted to mention, that Service Canada is going to be doing a pilot project. So some of us may hear of people getting registered for some like expanded return to work program with Service Canada. It's not open to the public. They are randomly selecting people to give them access to this program. And then they're going to be doing feedback from that population to sort of to look at improving how they try to support people, and to look at trying to put people in positions where it's not as terrifying to attempt to do some work either to survival, or to take that step into potentially trying to do some work to come off of the benefits. And that is it for my bit. Thank you very much.
I was just asking if I actually have to talk to 11:45 or if we can just get this done early, because I probably don't have that much. The good news is I don't think I have to talk to 11:45, so we should all be free. So we're going to close out with some changes in employment law and employment-related benefits. And again, the purpose here isn't to give you the nitty-gritty nuts and bolts of exactly how this stuff is, how this works. It's just to give you an idea, oh, hey, that's a thing. And then there'll be lots of sessions throughout the next few days on this stuff. And if you need to look it up, then at least you'll know it's there. So these are the 5 employment-related things that I have come up with that people might want to know about. So if you could, I control my own slides. Aha, there we go. Number 1, paid sick time. So this was a long time coming. And this is another one of those things where it was a problem that was lurking in the background, but another one of those things that the pandemic really drove home how badly we needed it. Nobody should be forced with the choice of taking time off work for the good of themselves and for their coworkers, right? Like not showing up and spreading illness all over their workplace, or paying rent, or putting food on the table, or paying bills. So did we get everything we want here? No, I think we might have wanted to see a number that was a little higher than 5, but at least we've got something here. So workers are entitled to 5 paid sick days. That kicks in after 90 days of employment. So that 90 days roughly corresponds to that 3-month probationary period that we're familiar with. So after 90 days, you're entitled to 5 days of sick leave. You can't bank it. You can't carry it forward. It's per calendar year, use it or lose it. And the amount you get is based on your average earnings, exclusive of overtime. Overtime doesn't get rolled into that, and they average, I think, the last 30 days, what your earnings were, and that's what you get. Oh, and you don't need to use it consecutively. It's not like you have to go off for a week. You can use one day here, one day there, all the way through. They did put in a provision as well for unpaid sick time, so that if you've used up your 5 days, I guess you can take time off unpaid and not be faced with consequences, although it seems a little cold to saddle people with consequences for taking time off work. But that's the way it is, I guess. 2, the end of the federal pandemic benefits. Another one of these problems, like the story of the pandemic, is all these problems that were lurking beneath the surface. The pandemic drew them right up to the surface. And one of the big ones was, holy smokes, a lot of people aren't covered by the EI system. And the EI system just isn't coped to deal with mass unemployment like that. So the government responded with a whole series of federal benefits, the CERB, Canada Emergency Response Benefit. After that, the recovery benefits, all these federal programs that sort of fell under the umbrella of pandemic relief. Well, they're all gone now. They're gone. So they're gone, at least from the perspective of people getting money. For your lives, they may not be gone in terms of the government asking for their money back again, which seems to be an ongoing issue that some of you may have seen. The third, and by extension, as I mentioned, glaring holes in our EI system were exposed during the course of the pandemic, and the government brought in a whole bunch of temporary measures to make EI more accessible to workers, and more importantly, to make it simpler, a little easier to understand. Because for any of you who have ever sat through one of my employment insurance sessions, it's not a simple system to understand. So we had a bunch of pandemic benefits in slide 2 to cover people not covered by the EI system. But the flip of that was we also had an expanded EI system to reach out, grab more workers, make it easier for them to understand. Well, as of a couple of weeks ago, all the enhanced and expanded EI measures are done. The government's not going to renew them. So you'll have to learn the EI system again, I'm sorry to tell you. And there's good reason to do so. And I think it dovetails off what Ashley was talking about. For those of you who do a lot with the ministry, a lot with disability assistance, social assistance, well, not so much social assistance, disability assistance, the earning exemptions are going up. They're up, meaning people can do a significant amount of work and still be entitled to disability assistance. Well, those workers are also going to be entitled to EI, to employment insurance, and figuring out how this all meshes together and works together is important, quite important. So, yeah, EI is back and maybe more relevant than ever. Number 4. Oh, right, I do it. Yeah, so the bad news, the last 2 slides are the bad news, the end of all the temporary measures. If there's one silver lining that comes out of this, it is a commitment from the government to reform the EI system permanently. This is a system that goes back to literally the Great Depression. Like literally it comes out of the Great Depression. Work looks a whole lot different now than it did back then. We're wrestling with a whole bunch of issues. We've got entire worker populations we didn't contemplate with gig work, app-based work. We have employer misclassification of workers who are employees, misclassifying them as independent contractors to get out of their obligations. We've got a whole, the landscape has changed. So the government has gone through 2 phases of consultation. And I gather now we're waiting for the government to release its plan about how it's going to permanently reform the system to make it more accessible and easier to understand. So we'll see what we get. I don't know what we're going to get, and I don't know when we're going to get it. But stay tuned, because although the bad news is the end of the temporary measures, maybe we will see some permanent changes to the EI system coming soon. And lastly, one change, and I feel like I've had this on slides for about 3 years, keep saying it's coming, it's coming, it's coming, and then it sort of comes, but never really comes. I'm doing that again. The budget, the 2022 budget promised to expand EI sickness benefits from a maximum of 15 weeks to a maximum of 26 weeks. The minister has said that is coming before the end of the year. And this is important because for a lot of workers get trapped between the different programs. If you're hurt at work, you've got WCB. If you have a very serious long-term disability, you might have CPP disability open to you. Some people might be able to access disability assistance, PWD benefits. But the thing with EI is for those people who have an illness or a disability that's a little more long-term, but isn't necessarily going to mean entitlement to CPPD, EI has kind of failed them. The 15-week cap just isn't enough. It's just not enough for a lot of these situations. So this is a positive step. It's another one, would we have liked to have seen a higher number? Sure. Yeah, I think I would have liked to see a higher number closer to 50 or 52 weeks. But at the very least, we're moving in the direction here. So for those of you who deal with clients accessing EI, stay tuned, because EI sickness benefits will be increasing from 15 to 26. And that is the end of the employment-related updates that I think people should know. So I think we can take questions now. We do have time for questions. Is there a method to this, Lois? Or Lois has a mic, so Lois doesn't have a mic.
There.
There you
Okay,
go.
good. So we have one question from online. Someone is asking if anyone is able to comment on if there'll be an increase in PWD and income assistance allowances allowing for inflation. Alison?
Sure. Thanks for the question. So you heard Ashley talk about CPP benefits increasing with inflation because there is indexing to cost of living allowance for CPP. Income assistance and disability assistance are not indexed to the cost of inflation, which means that if there is to be any increase, it would have to happen at the political level by the government increasing benefit rates.
Oh, Arnold's going to bring a live question from Prince Rupert. Remote.
Hi, my name's Arnie. I'm the Aboriginal advocate here in Prince Rupert, living and working on the unceded territories of the 9 allied tribes of Metlakatla and Lekwalams. I wanted to address a couple of things to Vernon's presentation. First off, in regards to the day school claims, Vernon, I think we really have to be aware is a lot of what's going on now is many of the victims of the day school have applied for level 2 and higher, are being offered settlements that are lower than what they applied for. We have done in my office over 500 day school claims. I think we're in the neighborhood of 540 now. And I've noticed that we've managed to appeal and let the administrators know that we are not going to accept that settlement. And we were able to provide more information, and every one of the clients that we argued on their behalf was given the full settlement amount. With things being tight economically for everybody, I think that's something that we as advocates really have to pay attention to. So those that came for help to us don't get shortchanged by quick administrative decisions. Secondly, on the class actions suits, there are actually 2 more class action suits that are being in the works by Klein lawyers. One deals with Indian hospitals. I think the important thing here is under the day schools, if the treatments and the experimentation that was done on many of the students wasn't done on school grounds, they never qualified. Many of them were done in what they called Indian hospitals. Here in Prince Rupert, just outside of the town, there was a hospital called Miller Bay, where many First Nations students were brought from day schools, and dental experiments, full tooth extractions, entire teeth all removed, were being done. I think it's important that clients that we've dealt with in day schools also are aware of that action that is happening, and they can register with Klein to see if they qualify. And the last one in regards to another class action being launched by Klein lawyers is in regards to Indian boarding homes, where students were removed from their homes. Say if they were removed from a First Nations community here in the north, sent to Vancouver and put up in homes to go to school. There is also a class action suit in that. I think these ones will be coming to the forefront, and it's always good to be on board with it. If anybody wants a copy of the form and a little bit of a background on it, they can go to the Klein Lawyers site and look under class actions. One under Indian boarding homes, class action suit, and the other one under the Indian hospitals class action. I think it's important that we stay on top of that. Hawa, and I hope you all have a great conference. Sorry I can't be there, but house fires tend to take up an awful lot of time. So hopefully we'll be back at it soon, and look forward to seeing you all next year.
Vernon, do you want to comment at all?
All right, I'll try my best to answer these questions as a still fairly new advocate, and I'm still learning myself. As for the Indian hospitals and the boarding homes, I thank you for bringing that to my attention. I am aware of these. I haven't done really much work, so I don't really have much that I can give in that regard. As for the day school, it has been quite the process for us at the clinic. We've tried really hard to represent our clients the best we can, and having rejection letters from Deloitte has been difficult to say the least. It was supposed to be designed in a way to eliminate as much trauma as possible compared to the residential school class action. And in our experience, it hasn't really been that at all. In fact, it has traumatized a lot of the clients that we've seen, and including ourselves and others. So we're right now we're working on trying to come up with ways for aftercare. We're seeing a lot of clients come in with rejection letters. We don't believe that anyone is really a level 1. We've always advocated for having a higher level. And right now we're in the work of trying to rectify this situation. It's extremely concerning having clients who have been through some really terrible experiences, and then having to go back and do that work again and fight for that appropriate level. There's really no amount of money that will ever rectify what had happened or make things any better. I'm not sure if I'm really answering your question properly, but I 100% agree that we're trying our best to make sure that our clients are getting the levels that they deserve. So thank you.
Thank you. So any questions from the room?
Thank you. I just wondered if anyone here had successfully argued for actual shelter costs above the $75 for someone living in his or her car, and if so, what documentation was provided to get that additional money. I did have a conversation with our own service quality manager person. I always forget those initials. And she said for somebody living in her car, they would have to, and therefore needed to be warm in her car, they would have to calculate how much of the gas was being used for traveling and how much was being used for heat, which I understand, but also I was just curious whether anyone had tackled that successfully. Thank you.
Alison, anything to say?
No, I haven't been contacted about a case like that. I was looking at Sonia, but they shook their head. So
we've been expressing a lot of concern that people don't want to be in a position where they're having to produce documents that are impossible to produce or being turned down, like, because nobody needs another humiliating experience. And so, it's gone back. Like, I mean, this is very, very recent. So I'm still waiting to get the definitive, direction. Like, apparently some directives have gone down. I work in the downtown east side, which is very, has a huge houseless population. And so apparently some directives have gone out, and I've been told that some costs have been approved, but I haven't been given any details and nothing definitive around what kind of paperwork will be accepted. But I'm so happy to hear that people are coming forward. I've been hesitant to really publicize that these additional funds are available until we really are able to put together a little leaflet that says, hey, this is what's available, and, please, avail yourself of this very tiny amount of money that the ministry has very, only recently recognized the human rights implications of their current legislation and just how discriminatory they have been. It was really written in the 70s, I think, for people who own their own homes or something like that. So they're really slow, but the more we push that envelope, the more it's going to happen. So I haven't heard of any successful cases. So
I'll just comment that some of the policy change, I think, came about for the change in looking at what is an actual shelter cost and what can be a place of residence as a result of some work that was really done at the Moving Forward Steering Committee, part of the Advocate Ministry consultation. And Sonia is one of several advocates who had told some very compelling stories there about what denying shelter costs to people living unhoused meant. And so if you have compelling client stories, situations, and you're not yourself on the Moving Forward Steering Committee, contact someone that is, and we'd be really appreciative of being able to relay those situations. For those advocates that are new and may not know about the consultation process, there is a consultation process that's been in place between the Ministry of Social Development and Poverty Reduction, which administers welfare benefits, and advocates around the province for, I don't know how many years now, 6 or 7, maybe more. There's a policy committee that leads it called the Moving Forward Steering Committee. Tish Lakes at the back table is the advocate co-chair of the Moving Forward Steering Committee. And then there are numerous subcommittees that work on specific issues that have been identified as requiring more attention. So there is a committee, for example, that looks at overpayment issues and investigations done by the Ministry's Prevention Loss Management Services Branch, PLMS, another committee that looks at health benefit issues in Schedule C. There's another committee currently that looks at Canada Pension Plan disability issues that arise where the ministry may require someone on income or on disability assistance to apply for CPP disability benefits. There is a summary document that exists that has a description of all of the parts of the consultation and contact information for all of the committee co-chairs. I have uploaded it to SCED at the moment. I can't remember exactly where I put it. What I'll do after this session is upload it to the systemic update as well, so you'll find it there. The last piece of the consultation process is that there are also regular meetings at the regional level. So the ministry has meetings, I think, on a quarterly basis that are chaired by a ministry CRSQ manager, community relations and service quality manager for the region, with advocates in that particular region. And all advocates are encouraged to attend those. It's a really good way to make connections. CRSQ managers with the ministry are important contacts to have. It helps to know them when you're trying to troubleshoot an issue or a problem your client may be having with the ministry. You'll know who the CRSQ is and how to contact them, and they'll be familiar with you as well from the regional meetings. So I'll upload that to SCED for this workshop at lunchtime, and you'll find it there then. Okay.
Oh, hello. Oh. This is sort of related to the question about updates to shelter policy. My understanding was that they had announced allowing mobile phones as an allowable shelter cost and no longer just having it, I think, what do they say? It's single-use residential line in the policy, or I guess a landline essentially. And I'm curious if anyone has tried that, because I know with a lot of plans, and obviously it's only if the client has the ability to have a plan and a phone. You know, there's other things besides it being used as a phone. It's, you know, maybe internet or like data and that type of thing. If there had been like pushback at all from a decision to try and get that documentation as a allowable shelter cost. Ooh, Sonia.
That very thing has been the subject of many an agenda item on moving forward steering committee, and along with the push for the ministry to broaden its definition of place of residence and the allowable shelter costs. There was a huge push around, and I personally participated in that, around the cell phone thing, and not just the cell phone, but digital access as being another human right now. And that the ministry is not recognizing, and, you know, particularly this was very acutely felt during the pandemic, when so many in-person services shut down, and even funding for various places to access, you know, access to digital tools. But you know, the other thing we were trying to give, not just access to they only give like, what, $30 or something for a residential line. What I can say is that in practice, I can tell you for sure, I know that, I mean, I speak for my region only. That's the only region that I'm familiar with, which is like the Lower Mainland, Vancouver. They absolutely give money for a cell phone, even though the actual writing of the legislation makes it sound like they're only referring to a landline. They absolutely in practice recognize cell phones. And if you have a family that has been unsuccessful, like I know the very chair of the Moving Forward Steering Committee has personally extended an invitation for us to please put forward any names, like, you know, obviously you need consent from the client, but to bring this to their attention. So far, though, they were completely unwilling to raise the amount to create additional amount so that people can access internet or that, you know, anything like that. And on a related issue, they were also unwilling to add extra cell phones. So, when a family has like 2 children and they're 12 and 14, they need their own phones, and they're only giving like 1 line, so we wanted it to be taken out of shelter and have a separate benefit that would be for communication tools and connectivity tools. And the ministry so far has been entirely resistant.
Going to the other side of okay, I'm heading back to Trish, but I'll stop here along the way.
This question is for the young man at the end. I'm sorry, I missed your name. Please accept my apologies. My question is in regards to opening Pandora's box with our Indigenous people in regards to day school. And my question is not only with the advocates that's taking in the story from the clients, but also our clients, where they're consistently in a traumatized state of having to reemerge all the traumas that they endured in day school and residential school and just children in care. My question is because our Indigenous people are constantly in a traumatized state where it's opening doors to more substance use, to incarceration. And we can see it all over the streets in our communities because they're re-traumatized. And it's not only re-traumatizing the clients, but the generations after of learning what those stories were. And it's a huge sacrifice for our people to tell the truth of what's been happening. So my question is, in regards to the advocates that's taking in the story and our clients, is it mandatory or optional for counseling when doing the applications? Thank you.
Thanks for the question. My name is Vernon. So I recognize that the whole process is very colonial, and getting into it, believe it or not, I didn't really know much about Indian day school, and I thought, going through the Native Education College and learning about residential schools, I was very much surprised to hear about Indian day schools. After a few months of working on narratives, there was a moment where I think we had I had a client who was a level 5 who went through some extraordinary circumstances, and I needed a moment to reflect, and so I called my mom, and she said, Vernon, I'm doing my Indian day school claim as well. And for 40 years, she had never told us and our family that she went to Indian day school. So that says something right there. For myself and for the others, we most certainly would never expect any of the advocates to go through that process. We try our best to make it as easy as possible for our clients by giving them space and doing it at their own terms. And after the end of this, when it all ended, we had to sit down and do a healing circle, because we realized that not only did we traumatize the Indigenous clients, we traumatized ourselves. So we are looking right now into how can we look at aftercare for our clients and for ourselves, and that's really important. So we've and what does aftercare look like for our Indigenous clients? A lot of the clients that we have that come into the clinic, they live in the downtown east side. They don't have a phone number, they don't have an address, So it's becomes very difficult to try to maintain contact. But most importantly, we had offered, make it very clear from the beginning of the available resources to our clients, so they have that awareness. In retrospect, I don't think the clinic will actually be dealing with anything of this capacity because of the harm and damage that it has done. Luckily for me, I have those resources. I'm available to look after myself mentally and have someone to talk to. I worry about a lot of the clients who haven't been able to express their needs, and so it becomes very difficult to try to navigate that. It definitely changed my whole perspective. I definitely have learned a lot through the Indian Day School, and as much as they try to not re-traumatize and approach it from a non-colonial way, it was very colonial, and I kind of felt like I was part of that colonial process. The one thing I took out of it, though, was that I got to listen to stories that many have never shared, like my mother, and just being able to listen and to be there for them was what I took out of it. Unfortunately, we don't really get the results of what happens, we don't get to see if they get their settlement or not. So we're looking into possibly reaching out and contacting our past clients and just seeing where they are, if they got their settlement. I hope that's as close to answering your question. Yeah. Thank you.
Thank you. So I'll call this as the last question. And then if people want to, that gives you the option of getting out for lunch. We'll have lunch for an hour and then the walls will start to get pulled. So you'll get booted out at a certain point during the lunch hour. So I'll pass to Trish and close the session.
Thanks, Lois. I just had a quick question. I'm wondering about the 5 paid sick days, if that applies to part-time workers as well.
Yes. Yes, it does.
Real quick question. Thank you.
Real quick answer. Okay, so thank you to Alison, Zuzana, Kevin, Vernon, and Ashley. They've all off really busy with, the jobs, their regular jobs, and often this is extra work on top. So thank you very much.